Good day to you and welcome to another Paddocks Club tutorial. Today I want to talk about approaches to pets. Let's start off looking at the fundamentals. I think for me the fundamentals are threefold. Firstly, pets can be a very important part of residents' lives. Owners or tenants, pets, they form very, very close relationships with their pets, and especially people on their own or families with children can have very, very close ships with pets, which makes them emotionally attached to them at a very, very high level. But equally, pets can cause a regular disturbance. Barking dogs, dogs that terrorize other dogs and people, these can cause a real disturbance. So what for one person is a tranquil a part of life, something that's a comfort, can for other people be very disturbing. And of course, every scheme is different in its ability to cater for pets. Pets can unfortunately be a danger to other pets and to people. This thing is a reality, and sometimes trustees have to deal with it. I think it is worth saying that there are special categories of pets. Guide dogs, which are generally referred to as service animals rather than pets, and companion animals, where people genuinely need, for their own peace of mind, to have a companion. These do deserve special consideration. Within the context of the scheme, one has to be reasonable and take people's needs into account insofar as one can do so without negatively affecting other people's rights to the peaceful enjoyment of their common property. Okay, now the Act doesn't, in fact, specifically deal with pets, so the provision is always made in terms of rules. And the prescribed conduct rule 1 is the typical one. Yes, you can have pets. Your application for consent to the trustees can't be unreasonably withheld, but they can impose reasonable conditions. Okay, rules must always be reasonable, not only in the way in which they're phrased, but also in the way in which they're implemented. But those must, of course, take into account the scheme's particular circumstances. The situation with pets in a sectional title scheme that's in fact entirely freestanding houses would be quite different to a high-rise block of flats where there are no balconies, for example. Now, rules must apply equally to units put to substantially the same purpose. In my time, I've come across a scheme which has, I think, validly differentiated between the garden flats, where there is room for pets to be outside and that sort of thing, and other flats that don't have balconies and any facilities. I think that would be a reasonable sort of distinction to make. And of course, the body corporate has the power to do what? Well, to do whatever may be necessary for the management and control of the common property. So whilst the Act doesn't specifically refer to pets, it does give an overall power which allows the trustees, acting as the delegates of the body corporate under Section 37 of the Act, to do what is sensible and necessary. So let me give you a few little stories as to this, how this sometimes plays out. There was a scheme which was the subject of a long court case in which a very small dog kept, when it was outside in a lady's big bag, never put its feet on the common property and never defecated or anything else, wasn't even really seen by other people. The trustee said, look, we've got a no pet rule, there are no exceptions, this pet must go. Well, after spending a lot of money, the court said, no, let's be reasonable. There was no nuisance, there was no allegation of barking or anything else that wouldn't be reasonable for the trustees to make this pet go, notwithstanding the no pets rule. So they go, bear that in mind. You've got to look at the circumstances. The second story is of barking sausage dogs, a pair of them, kept by a tenant, and this was brought to me in an opinion I did, where there was a series of complaints by a neighbour that these things barked every time the neighbour's away, and they barked consistently, and it was absolutely intolerable. When the situation was investigated, what was found was that this particular person was undergoing some stress in his life, and he had to be at home all day because of high blood pressure and other things, and he was showing an absolutely abnormal sensitivity to the barking of the dogs. It wasn't all day, and it wasn't even particularly loud, but it annoyed him, and he
allowed it to annoy him. Other neighbours gave written evidence that they never heard the dogs, even when they did stay at home. So you've got to make sure due process brings out the full story with these things, and that you get completely independent people to give input before you make decisions such as the pets must go. The third story, a little bit more aggressive, I suppose, I've entitled "Every Dog is Entitled to One Bite." You don't really know whether a dog is aggressive unless it acts that way. You know, it can seem nice, but the day that it bites another dog, the whole situation changes. And pray God it never happens, but the day it bites a person or a child, the whole world will change very, very, very substantially. So dogs can be presumed, depending on their breed and that sort of thing, to be docile. But dogs do act differently. Nervous dogs may snap and that sort of thing, if they're not of a particularly hostile breed. But once a dog has displayed aggressive behavior, the trustees have to be tremendously careful. If they allow that dog to continue to roam the common property and something happens to somebody, there could be very dire results for the HOA or the scheme involved. It really doesn't make sense. You need to impose very, very strict conditions and make sure that that is extremely unlikely to happen again. Otherwise, the dog really should go for the benefit of everyone in the community. Thank you very much for watching this Paddocks Club tutorial. I hope it's of assistance to you.